كلية الفقه الحنفي تقدم.
بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على رسول الله. So inshallah today we will finish off the factors that prevent a person from inheriting. So we firstly mentioned regarding blocking last time. We talked about the hajj with the blocking. Now we move on to prevention, hirman, which we will discuss different types, different factors that will lead a person to become, in essence, prevented from inheriting, deprived of inheriting, in essence. Here we'll also discuss the difference between this one and the previous one. What is the actual difference between them? Just to make it very clear, we'll discuss that inshallah. So we'll go through all the different factors. There are 5 factors altogether that will prevent a person here in this type of prevention from inheriting. So we'll talk about all of these in detail, going through each one's rulings. Then we will move on to certain important rulings that a person should remember when it comes to shares and when it comes to the people who are entitled to those shares. So the shares of inheritance that are discussed in the Quran, we'll just list them to show you there's only 6 of them. And the people who have been entitled to inheritance shares, fixed Quranic shares, who are the Dhawil Furud, there are 12 of them all in total, 4 men and 4 males and 4 females. We'll go through the list of that also. And then we will discuss who always inherits. So this is something to remember because certain people always inherit. They will never be blocked, basically. They won't be blocked. They may be prevented. They may be prevented from inheriting if they, for example, commit murder, all of those kind of things. They may lose the entitlement of inheriting, but they won't be blocked by anybody. Then we'll go through also the beginning stages of how to calculate the inheritance shares. So when you're talking about the actual shares, how do you go about actually giving out the shares now? So there are certain rules, and we'll go through rule number 1, inshallah. Bismillah ar-Rahman ar-Rahim. So now we move on to continuing regarding the factors that prevent inheritance. We started last time this particular discussion. We talked about the first type of prevention from inheritance, which was called the hajb, which was called the blocking. Now, as we will show here, we will now move on to the second factor, or the second way in which prevention takes place. So this is called, in essence, the hirman. So how a person is deprived is through hirman. So this is number 2. In contrast to total blocking, the hajbul hirman, when we talked about prevention, which is hirman also. So both of them are hirman. Some people get confused. That's why I'm contrasting them to make you understand. This refers to when the heir is, where the heir loses, where the heir loses their right to inheritance due to certain preventative factors, meaning they lose the eligibility to inherit. This means that there is no circumstance in which they will inherit. Whereas in contrast, we talked about the hajbul hirman, the hajb, the blocking, in that one, there was temporary type of blocking where there's a blockade. Once that blockade moves, the person will inherit. Here, there is an actual deprivation, that you are deprived of any inheritance because you do not have, no longer you have the eligibility to be able to inherit anymore. This is what's happened over here. So what are these reasons as to why this takes place? So there are 5 factors that prevent inheritance. this kind of prevention. First is slavery, which is riq in Arabic, then murder, which is qatl, then difference in religion, meaning tabayunud darain, or different in religion, tabayunud dinain, deen, and number 4, difference in land, which is tabayunud darain, and 5th is confusion about inheritor, ishtibah of warith wal murath. So these are 5 factors that will in essence prevent the person from inheriting. Any of these factors will prevent the person from inheriting. Now we will go into detail regarding each one. So the first factor, we have slavery, right? So slaves can be classified as either full slaves, where you have the abd al-mutlaq or a mukatab, or partial slaves. We'll discuss, for example, you have a mudabbar and walad. Slavery is considered complete, meaning you will be a full slave when the slave is inherited by the master's heirs upon the master's death. So if the slave can be inherited, then this slave is a complete slave, is a slave who is fully a slave, meaning, and is not a partial slave. A partial slave can't be inherited in essence. Mudabbar and walad in essence. So what are these? Abdul Mutlaq, Mukatab, what are these? So now we discuss that. So a Mukatab is a slave who enters into a contract to pay a set amount for their freedom. So the master said, or they have said, whichever way around, doesn't make a difference, that if you pay this much, then you are free. And obviously the other accepted this. Then this slave will now become a mukatab, in essence, we call. So once they paid that amount, they will be free. Then we have a mudabbar, which is a slave promised by their master to be freed upon the master's death. So the master said to them that after I die, you are free. So this is a mudabbar slave. And a walad is a female slave who gave birth to the master's child. So he's given birth to a child, and a master has claimed this child, saying, this is my child. So as soon as the master makes this claim that this is my child, this slave girl now transforms from a normal slave girl to an walad, the mother of the master's child. She cannot be sold and is freed upon the master's death. Just as the mudabbar, he is going to be freed on the master's death, and he can't be sold too. And lastly, al-abd al-mutlaq is a general term for a full slave who is neither a mukatab, mudabbar, or walad. So if they're neither of them, they're just an abd al-mutlaq in essence. I mean, you could call him different things as well, but this is what it is so far. Now, if a relative of the deceased is a slave of any type, any of these type, they are prohibited from inheriting, or they're prevented, should I say, from inheriting, as slaves cannot own wealth. So therefore, they can't inherit anything. Furthermore, a slave cannot block other relatives from inheriting the estate, meaning they cannot be considered at all in the distribution of the inheritance. So if, for example, a person passed away, the deceased has a brother who's a slave, that brother will not be considered when it comes to inheritance at all, because they have not got the eligibility to be able to inherit because they're a slave. So this factor of preventing inheritance is not obviously applicable nowadays in modern day, because slavery doesn't really exist. So we pray it because obviously we study it because it comes in the books and something that we need to know, but otherwise applicable, not really. Then we move on to the second factor, which is murder. Now, this murder, any murder, this is a general rule, any murder that necessitates either equal retaliation, which we call qisas, or expiation, which is kafara, either of the two, will prevent the murderer from inheriting from the victim. So whoever the victim was, whoever the person murdered was, this murderer will not inherit from them if that murder necessitated qisas or kafara. That's the point. So now, to understand that, you need to understand the different types of murder then. So in Islam, in the Sharia, there are 4 types of murder, and obviously somewhat relates to what murder would be nowadays in many places as well. So many jurisdictions, so people can understand this. Number 1 is intentional murder, which we call qatlul amad. This occurs, by definition, what is intentional murder according to Sharia? This occurs when somebody intentionally kills, so intent is there, intentionally kills, that's number 1. An innocent person, that's what has to be the case as well, using a weapon typically used for killing. So you use the weapon typically used to kill, so for example, a sword, a sharp instrument, a sharp stone even, a gun, or fire, like you burnt the person. So the murderer is sinful in this case. They'll get sin because they intentionally did a sin. They committed murder. And liable for equal retaliation, qisas, or blood money, which is diya. So can you see here the qisas applied? So because the qisas applied in this particular case, this will be a factor which will prevent a person from inheriting. Number 2 is we have the quasi intentional murder, which is shibhul amad, qatlu shibhul amad, resembling, you can say, the intentional murder. So this happens when someone intentionally kills an innocent person. That's the same as the previous definition, but this time using an object not typically used for killing. So for example, a normal stone, not a sharp one, a normal one, a stick, they beat the person up, to death with a stick. Not a stick which is maybe used to kill, like one blow and they died. No, a stick like a normal stick, or a chair, or like a bag or something, right? Something which you wouldn't normally use to kill a person. So the murderer is again sinful because the intent was there, and must pay blood money now. So they must pay this diya, which we discussed above, and perform expiation. So they have to also give expiation, the kafara. So because they have to give kafara here now, that's why they will no longer inherit. But equal retaliation is not applicable here. The qisas is not applicable over here. Number 3 is accidental murder. This is qatlul khata. So this occurs when someone kills an innocent person, again innocent person, but unintentionally this time. So unintentionally while performing another action. So this could be with whatever instrument. So an instrument that was normally used for example, hunting. You're doing hunting where a human is mistaken for an animal. So you were shooting somebody in the distance, you were hunting, and you thought it's an animal, and you shot through the trees or through the bushes, and you obviously thought that this was an animal, but it turned out to be a human being. So while the killer intended to shoot, there was an intention to shoot this object, this particular person or this thing, but the killing of a human was not the goal. The murderer is not sinful, therefore, for murder because it's accidental, but blood money and expiation are required. Okay, so there is still diya and kafara still required. Equal retaliation, again, the qisas is not applicable here. So here, because the kafara became necessary, that's the reason why we will have this type of murder also being a preventer. And lastly, we have here a pseudo-accidental murder, which is ma ujriya majra al-khata, meaning murder which has been just taken to be like a accidental murder. So this occurs when someone unintentionally, same as before, unintentionally causes the death of another, and the action leading to the death was also unintentional. So previously, the action was intentional. You shot intentionally. Here, you didn't do this action intentionally. So for example, a sleeping person rolls over onto their child. So there's a person who's sleeping, typically maybe a mother sleeping next to their child, and they roll over onto their baby, and the baby obviously causes death of the child. So causing death. Or a person accidentally knocks over a glass shelf, which shatters, and obviously it ends up killing someone because the shattered glass falls onto the person's, in a person, cutting their veins, their arteries maybe, and it ends up killing a person. Or a man strangles his wife during a nightmare. Okay, because that one I mentioned because that one actually happened. There is a article in the Standard on this link where a man strangled his wife whilst having a nightmare, who was regular with sleepwalking and things, and he got away with. In court he proved this. There was accidental. So anyway, he believed that it was an attacker or intruder. So if this happens, any of this kind of way happens where they didn't intend the action, right? It was accidental because whilst the person's sleeping, the actions are not going to be taken into consideration. So in these cases, the killer is not sinful. There's no sin, but blood money and expiation are still required. So there is still the same as previous. That's why we're calling this ma ujriya majra al-khata. It's going to be considered to be like a khata murder, just like the previous one, even though it's not the same as the previous one. Previous one, you intended to do the action. Here, you didn't intend to do the action, but we're still going to consider it to be similar to the other one. So it will necessitate the diya, and it will also necessitate kafara. So in this one, because kafara is necessary, so this one will also prevent a person from inheriting. So moving on. Now, certain killings do not necessitate equal retaliation, meaning the qisas, or expiation. They don't necessitate the kafara, and thus do not prevent inheritance. Examples include killing by a state-sanctioned authority. So if, for example, somebody who is the executioner kills someone because they were sanctioned by state to do so, so that will not necessitate any sort of qisas, any sort of kafara. So there will be no prevention here. Likewise, if it was a killing by a child, so a child is not held accountable for their actions. So it was a child that ended up killing their parent, for example. This won't prevent this child from inheriting. The child will still inherit from that parent. Or an insane person, you get the same point. Or killings resulting from a secondary cause, which we call qatl bisabab. What do we mean by that? Such as a person falling into a ditch dug without permission. In such cases, only blood money may be required. So if there was a ditch that you dug, you didn't put proper signage up, and somebody fell into it, this person you would normally have inherited from. So obviously this is not a intentional killing, unless the person claims that I intentionally dug this so that this person falls in and dies. Then obviously the intention is there. But here we're talking about that there was no intent. There was an actual ditch that you had dug there, and they ended up falling into it, and this is a secondary cause. Which the person fell in because they weren't looking properly, right? They should have looked to see where they were going, where they were walking, but they weren't. So they fell in and they died. And it was, sabab of this was the person who dug the ditch. So this won't prevent the person who dug the ditch from inheriting. Okay, so these are all types of killings. Hopefully people have understood now. Now we move on to the third type of preventer, which is difference in religion, which we call tabayun ad-dinain. The religions are different. So now this, we have to understand that a non-Muslim heir cannot inherit from the estate of a deceased Muslim, and similarly, a Muslim cannot inherit from the non-Muslim. So it works both ways. The Muslim can't inherit from a non-Muslim, non-Muslim can't inherit from the Muslim. And non-Muslims include any religion, whatever non-Muslim they may be, even if they're a atheist, agnostic, whatever it may be, all considered the same. So a Muslim can receive a share from a non-Muslim's estate if they are included in a bequest, only if they're included in a will. So, a will would be, in essence, a bequest. So that if they have included this Muslim in the estate, then they can receive. And Similarly, a Muslim can make a bequest for a non-Muslim. So that can also happen. If a Muslim is not included in a non-Muslim's bequest, they can still inherit, can still receive a share if all the heirs agree to give them. If they agree to give it to them, then that's fine, because it's their share, and they're giving it to them. Yeah? So in this case, it will be considered a gift, not an inheritance. And there may still be allowances for Muslims to inherit from their non-Muslim parents or father under specific circumstances. Obviously, consultation with a scholar, a mufti, is required to ensure proper application of this ruling, because there are certain rulings, like the Indian jurist. We have Mufti Zafar Uthmani in his book Imdadul Ahkam. He issued a fatwa permitting a Muslim to inherit from their Hindu father under specific circumstances. So these rulings are based on the opinion of Maulana Ashraf Ali Thanawi, who provided allowances in such cases. So anyway, this is certain allowances that can be discretion given to the Mufti to be able to rule depending on a certain case. According to Islamic law, two non-Muslims from different faiths can inherit from one another, though. So if they were both living under Islamic law, then they would be able to inherit from one another, even though they are from different religions, as all other non-Islamic faiths are considered equal in this regard. So they're all considered one. So this is just very easy difference in religion to understand. So we move on to the next one. Difference in land. So when it comes to this tabayun ad-darain, non-Muslim residents, it only applies to non-Muslims in essence. So non-Muslim residing in different lands will not inherit from one another. So if there's non-Muslims living in two different lands, they won't inherit from one another, even if they are relatives. However, this does not apply to Muslims. Muslims living in different lands, who can still inherit from each other regardless of where they live. So this preventer doesn't apply to Muslims. It only applies to non-Muslims. And lands are considered, how is a land considered different? So lands are considered different when their rulers and armies are distinct, when they're different, okay? However, if there is an alliance between the two lands, they are legally treated as one. In hukman, they are one, though they are actually different, allowing the citizens to inherit from each other. Difference in land can be classified as either real, hakiki, or legal, hukmi. So what do we mean? Real difference occurs when one non-Muslim resides in an enemy land, in a Darul Harb, and another in a Muslim land, in obviously the Muslim land, as a tax-paying citizen, which we call a dhimmi, or when both reside in different non-allied enemy lands. So that one lives in one Darul Harb, the other lives in another Darul Harb. In these cases, they cannot inherit from one another. And legal difference arises when, for example, one person in a non-Muslim, is a non-Muslim residing in a Muslim state on temporary visa, which we call a musta'min. They've taken visa and entered into Darul Islam, into the Muslim land. While the other is a dhimmi. The other one is living in Darul Islam paying taxes, so they have residence to stay in Darul Islam. So now, although they may live in the same country, they're living in the Muslim land, they are legally different because the visa holder has an affiliation with a non-Muslim land and retains the option to return there. In contrast, the dhimmi has no such affiliation or option, therefore they cannot inherit from each other. This will also give you a clue as to why we don't allow them to inherit each other, because then we're strengthening them against us by allowing them to inherit such large amounts of wealth and then to equip themselves against us to fight us. So that's the reason why it will apply to non-Muslims, this difference in land. We're not going to allow them to strengthen each other. So that is this factor which will prohibit. Next, we have last one, number 5, confusion about inheritor. So which we call ishtibahu warith wa murith. So if there is a confusion of the inheritor, who is the one who is inheriting from who? So this situation arises when there is an uncertainty about which relative died first, leading to a confusion over inheritance. So consider, this is just an example, consider a man traveling with his only son, and both tragically die in an accident. If it is established that the father died first through post-mortem or something, right, and the son would be included in the calculation of the father's inheritance. So obviously the son died afterwards. So the father died first, then the son died after that. So the son was still alive when the father died. So therefore the son would still have inherited the father. And subsequently the son's inheritance will then be divided to his heirs. So that's the idea. So conversely though, if the son died first, the father would inherit from the son. So that's if you can determine time of death. However, if it cannot be determined who died first, neither the father nor the son can inherit from one another. So this uncertainty prevents both from being considered heirs in each other's estate. So this is what we call the ishtibahu warith wa murith, that we don't know who is inheriting from who, so we just cancel them both out. So this is the final preventer, a factor, should I say, which prevents a person from inheriting. Right, so the next section we move on to today is actually allocating the shares according to the Sharia. And we talk about those who are entitled to these shares. So the shares, we understand the Quran mentions 6 types of shares. We have 1/8, 1/6, a quarter. Then we have 1/3, a half, and 2/3. So these are allocated shares that are mentioned in the Quran. In total, 12 categories are mentioned. 4 males and 8 females. These 12 are known as the fixed Quranic shareholders, which we discussed, the Dhawil Furud. Now, the males are, for example, the father here, paternal grandfather, husband, and the uterine brother. These are the Dhawil Furud mentioned by the Quran in male. Females, mother, wife, daughter, paternal granddaughter, maternal and paternal grandmother, which we call the Jadda Sahiha. Then the full sister. Full sister, the one who shares the same mother and same father, the Ukht Aini. The agnate sister, the one who shares the same father but different mother, the Ukht Allati. And lastly, we have the uterine sister, who shares the same mother but different father, the Ukht Akhyafi. So these are males and females that have been allocated a share in the Quran. Now, parents, another point to remember, parents, children, and spouses will always inherit, while others do not always inherit if certain others are present. For example, a grandfather will not inherit if the father is present, and a sister will not inherit if the father or sons are present. So you have to remember certain things here. This is just a general overarching concept that we want to try to remember. The shares that are mentioned, these are the only shares that are going to be there, which are fixed. Then you've got these Quranic shareholders, 4 males, 8 females, and you got parents, children, and spouses who always inherit. They're never blocked from inheritance. So this is in relation to the shares. Now we move on to actually calculating the shares. So if we see this, calculation of shares. So how are we going to actually calculate the shares now? So once the shares of each relative are allocated, so you've worked out the shares of each relative that is alive after the deceased. So the estate is then distributed according to the divisor. What do we mean by divisor? We'll talk about. So which determines, this divisor determines how many parts the entire estate will be divided into. This is obviously known as the divisor. The divisor is the amount that we will divide the property or the estate into. The method of working out the divisor will now be explained. As mentioned previously, there are 6 different shares mentioned in the Book of Allah Most High, which can now be divided into 2 groups. So the 6 shares, we'll put them into 2 groups, which is going to be important for us to work out the divisor. First group we have is half, quarter, and eighth. I'm sure you can understand the relationship between them. And group number 2 is a third, 2/3, and 1/6. And I'm sure you can understand the relationship between them. So you have to understand group 1 and group 2 and understand it in that order as well. Group 1 is half, quarter, and eighth. That's going to be vital to remember. So now we will follow certain rules. There are 4 rules altogether. And these rules will allow you to be able to work out what the divisor would be, meaning how much are we going to split the property of the deceased, the estate of the deceased into. So rule number 1, very easy and simple rule. When these shares occur individually, so if there's only a half, or if there's only 1/3, or if there's only 1/8, does that make sense? So if there's only something like this, then when the shares occur individually, the divisor is equal to the denominator of the shares. So obviously if there's half and that's the only share that's been given out to somebody, then the divisor will be 2, because the denominator, the bottom number in the fraction here, is 2. Likewise, if, for example, the only share being given out, the only share is 1/3, then the divisor will be 3. And I'm sure we can understand so on. Now, before we actually go on to give examples, you have to know now, before we give examples for this rule number 1, you're going to have to know how to write out the scenario, how the inheritance case is depicted and written out. So I'll explain this now. There's some steps that you have to follow. It's very easy if you get used to it. First step is representation. How do you represent the estate and the inheritors of the deceased? So draw a horizontal line. This is universally done. Everyone does it in this way. So this is the method we follow. So you draw a horizontal line to represent the deceased, like the deceased is sleeping now, they've died. So this is the deceased, and beneath the deceased you now list relatives. So below the line, or list all the living relatives of the deceased across horizontally. So you start with the spouse on the right side. If there's a spouse living, you write the spouse. So either the husband or the wife, always write them first. If you follow this method, it makes it easier later on. Followed by fixed Quranic shareholders. All the Dhawil Furud will come next in order. So you write them in any order you want to write them in. So if there's the daughter, the sister, just write them all in, the Dhawil Furud. And then the agnetic shareholders last on the left-hand side. So starting from the right side on your page, if you draw a horizontal line, then now you list all the heirs. Okay? This will become clear when we do the example. Allocate, number 3 is allocate shares. So once you've listed the heirs, now what you do, write down the designated shares each relative will receive under their name. So is it a half? Is it a quarter? Is it nothing? What is it? So the fraction you write down in accordance to the table that we discussed. Number 4 is determine the divisor. So once you see that, you now work out the divisor according to the rules that we're learning. So you calculate and note down the divisor required for the distribution on the right-hand side of the line. So on top of the line, that line that we drew across representing the deceased, on the right-hand side on top, we write down the divisor. Then number 5 is redistribute. So distribution, allocate each individual share accordingly and write it underneath. So you write down each individual's share from that divisor now. And again, like I said, this will become clear as we do the example. And the last step is validation. So you sum up the distribution, whatever you shares you have given to everybody, and you add it all up to make sure it matches the divisor. And you write that sum on the right hand side equals, you write all of the shares that you've given out, you write equals, and you write whatever it equals. If there's a discrepancy between what you've given out and the divisor, then clearly there's something that's wrong. There's an error in your calculation. So that is something needed to be taken into consideration. So what do we mean by all of this? Let's give an example. So example number 1, deceased has left behind a daughter and a full brother. So deceased's daughter and the deceased's full brother. Remember, this is always going to be in relation to the deceased when we talk about the whose daughter is it and whose brother is it. So we draw a line, like I just did. We drew a line all across the page. Then underneath the line, we write daughter and you write full brother. Then we write down, the next step is we work out the shares. So the daughter, because there's nobody else here besides the full brother, the daughter will get her half. And the full brother will become the agnetic shareholder. He'll become the agnetic shareholder because there is nobody in amongst the will furud left anymore, no fixed Quranic shareholder. So we then go to the next category, if you remember, and the next category in terms of distribution was the agnetic shareholders, and the only agnetic shareholder here is the full brother. The Hashia, if you remember the sibling of the deceased, so he becomes the agnetic shareholder, which I'm going to represent as an Ain Asaba. Okay, you can represent it how you want to. You can write A if you want to. You can write agnetic if you want to, agnetic shareholder if you want to, however you want to write it. So you see the daughter gets a half and the full brother gets the rest of it. So now we work out the divisor because we've given out the shares. We work out the divisor. There's only one, rule number 1 applies. There's only one fraction used. So we make it from the divisor. So now the divisor will be 2. So we write down the divisor now on the top there. I've put it into like a diamond shape. You don't have to do that. I just like to do that so it makes it easier for me to remember, to see it, especially when there's a lot of numbers going on. So the top right hand side, you put the divisor here, number 2. Then next stage, you give out from 2 because you're going to distribute all of the estate of the deceased. Whatever the estate of the deceased is, you're going to distribute that into two portions. Then you're going to give daughter half. So you're going to give her 1 out of the 2. And the remainder goes to the full brother, so he gets 1 as well. So then you see here, you would then total this up. So you total up 1 plus that 1. And you see, does it equal 2? And obviously it does. So then you've got it right. You would actually write it in there. I haven't written it here, but you would write it there, as you will see in further examples later on. Just do one more example here. The deceased has left behind a husband and a son. Husband and a son. So you've got a quarter. Husband gets a quarter because there's a child, and the son gets the remainder because he is the agnetic shareholder. So now we work out the divisor would obviously be 4 because that's the husband's denominator. So divisor is 4. We write that on the top above the line there. And then we give it out. So the husband gets 1 out of the 4 because he gets a quarter out of 4. So he gets 1. And the remainder goes to the son, which is 3. So you add it up now. 3 plus 1 equals 4. And it equals our divisor. So then we're okay. We've done it right. So this is how you give out the actual shares to the heirs now. Method is this. Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salam wa rasulillah. So alhamdulillah, today, just to summarize what we went through all the different types of preventing factors from inheriting. So those factors which prevent a person from inheriting, we talked about there's 2 ways a person doesn't inherit. One is hajb. They don't inherit if they're blocked by somebody, whether it's partial or total. That was the last time we did. Then today we went on to a person doesn't inherit if they're prevented from inheriting. And this type of prevention is like a where a person loses their entitlement to inherit. They no longer are eligible to inherit, so they are deprived of this inheritance. And how does a person become deprived of inheritance, prevented from inheritance? There were 5 factors. One is slavery, the other was murder. Murder was where if it necessitated qisas or kafara, then that type of murder was a preventer. Then there was difference in religion. So a Muslim can't inherit from non-Muslim, non-Muslim can't inherit from Muslim. There are certain exceptions, which we did. Then difference in land, which only applies to non-Muslims, and a confusion in inheritor, whose inheritor. When there's a confusion there, then they will not inherit each other. So we went through the details of that today, alhamdulillah. Then we went through those, we went through certain just factors that a person should remember, the shares that are mentioned in the Quran, and as well as that we went through the people who are mentioned in the Quran that will inherit as well. And we mainly learnt that the parents, children and spouse will never be blocked by anybody. They will always inherit. They may be partially blocked, but they will never be completely blocked. And then we went into how to calculate the inheritance. So I just wanted to give certain questions just so that people can practice this as well. And then I will also reveal the answer. So I will give the question and reveal the answer, but I want everyone just to practice. Obviously later on other questions will come anyway, as you normally have questions, but this is just so that we can practice and you can get the answer straight away before you go on to actual questions. So rule number 1 we did, and I'm going to give a question regarding rule number 1. So if the deceased leaves behind a wife and a son, if the deceased leaves behind a wife and a son as such, so what happens in this case? Oh, you can't see it. If I do it again, hopefully you can. So if the deceased leave behind the wife and a son, there we go. So what happens in this case? You can pause the recording and then reveal the answer. So you write the wife first, then son. Wife will receive the 8th, son receives everything else. So divisor is out of 8. You put the divisor on top, 1 for the wife out of the 8, and the remaining 7 goes to the son. Another example, the deceased leaves behind a mother and a full brother. Mother and a full brother. What happens in this case? So again, you can pause here. The answer, mother, full brother, you write down, mother gets 1/3, full brother gets the remainder. So the divisor would be 3, you make it out 3, mother gets the 1, and the 2 goes to, the remainder goes to the full brother. Another example, and I want everyone to do this themselves. So you got deceased has left behind 2 daughters and a paternal uncle. 2 daughters and a paternal uncle. So how would you do this? You can pause here again. Okay, the answer, this is what will happen. 2 daughters get 2/3, uncle gets that remainder. So we make it out of 3, because we make it out of the divisor out of the denominator. So 2 goes to the daughters, 1 remaining goes to the uncle. And we do one more. Deceased has left behind a father and son. So what happens here? The answer, father gets 1/6, son gets the remainder, father. So you make because the father shares out of 1/6, the denominator is 6, so you make divisor out of 6. So you distribute in this way, 1/6. 1/6 of 6 is 1, and then the son gets the remainder. Hopefully this has been clear.